Good afternoon, William.
Good afternoon to you, Quintin. Good afternoon, everyone. Thank you very much for joining our remote seminar. There's a lot to like about these remote sessions. Even on a beautiful sunny day like this, you can sign in for your CPD points. You can decide we're talking rubbish. You can go and sit in the sun or read an improving novel. And from our point of view, we can't even see who's bored, who's shaking their head in despair. And I probably don't need to tell you where the lavatories or emergency exits are. Now, you will soon realize that this is not going to be any sort of a set piece lecture. It's really a discussion between Quintin and me about duty of care. I'm afraid there's no free handout. And there's a reason for that, because this this webinar is based on a chapter that I've written for the new volume 2 of Kemp. Kemp volume 2, one of the 4 volumes, is one that some of you may have seen. I don't think anybody has ever been heard to open it before. I think almost certainly it contained a whole lot of material that's now easily available on the internet. And so we decided that what might be useful, rather more useful to subscribers, is to include a series of chapters about typical liability issues in personal injury litigation. So we've got duty of care, this chapter. Another one I'm writing is occupiers liability, but we're covering a wide range of subjects: sexual abuse, statutory duty, head injury claims, spinal injury, product liability, occupational diseases, sporting accidents, animal accidents, and so forth. And we're doing it in a slightly more focused way than you find in Clark and Ninsell and Charlesworth, the idea being that we will look at the issues of liability really with a personal injury focus. And we hope that may be useful to people and encourage them to buy the volume. So that's where the material that underpins this talk can very easily be found. After which commercial introduction, let me say that we are going to begin by discussing what we actually mean when we say there's a duty of care. Now, we would all like to think we act carefully and responsibly when we do something, especially when we do something that people may take seriously or rely on. But we don't expect to get sued when we get wrong something, especially in the social context, or indeed in the general context. Otherwise, weather forecasters telling us it's going to be a rubbish or a beautiful bank holiday, when they get that wrong, would find themselves on the wrong end of a claim. Now, they may have a moral or a contractual duty, if you like, to talk sense and to be careful, but that doesn't mean that can be litigation in which they are the defendants. And probably the classic illustration of where there is a moral duty but not a legal duty, when you can change the facts and it becomes a legal duty, pictures, let's say, Quintin and me walking along a cliffside road or path. I'm telling him about one of my really very interesting cases. And I go on and on about it. And he grows so bored that he loses concentration and is about to walk off the edge of the path and fall 150 feet from the cliff below. Now, I can see that this is going to happen. That's foreseeable that he will have a terrible accident. We are physically proximate. But is it reasonable to impose a legal duty on me? I certainly have a moral duty to say, Quintin, look where you're standing, look where you're walking. But I owe absolutely no legal duty to do that. You don't need to change the facts very much to introduce legal duty. For example, if, maybe I'll remember this or not, Quintin were an 8-year-old boy and I was taking him for a walk because I promised his parents I'd look after him, I would certainly owe a legal duty to tell him to be careful. And I would suggest that that is, and is often used by the judges as a classic illustration of the distinction between moral and legal duty.
In another context in which we see people using the duty of care, saying that there's a duty of care exists, is in say, the sporting context. A classic example of that is that Baroness Grey Thompson wrote a report in 2017 for the government entitled Duty of Care in Sport. And in that paper, she dealt with issues such as helping elite athletes go back into civilian life after their careers in athletics are over. Similarly, there's quite a lot of chat in the rugby community with clubs preparing rugby players for civilian life after their careers when they lose all of that camaraderie and purpose. Now, people use the words there's a duty of care, but what it really is an assumption of, say, moral responsibility, which might not be fulfilled, and that might be open to criticism. But if it isn't fulfilled, that doesn't result in, say, an actionable breach of legal duty.
Yeah, exactly. And one has to bear in mind that imposing a legal duty has economic consequences. So if you look at the sporting bodies, especially the smaller clubs, for example, imposing a legal duty upon them would have commercial consequences way beyond our expectations, even if they could get insurance, which they probably couldn't. But can I just talk to you about an example that came from a real life case, which seems to me to demonstrate how fact sensitive it is where there is a legal duty and where there's not. And it's a case that I did against the late lamented Richard Davis in our chambers. He was acting for a claimant who was a 16-year-old boy. I was for the defendants. And in a nutshell, the facts were these. The claimant and the defendant's son, together with 3 or 4 other boys of about the same age, were celebrating a birthday. They went into London, and they were old enough to look after themselves. In London, did various things, and in the early evening, they came back to the house in North London, announced their arrival to the parents who were sitting having supper in the kitchen, and said they were going to play on the trampoline in the garden outside. The parents said, fine. Now, all the boys had been to the house before. All the boys knew that the general rule in these used trampoline things is that you only go on one at a time. They all knew that. They didn't need to be told that. The parents didn't offer any supervision, didn't give any particular advice. And the kids started to play on the trampoline, initially one at a time, and then 2, 3, 4. And eventually one of them was stupid and jumped on another boy's neck as he lay on the trampoline, and he was rendered tetraplegic. The injured boy brought a claim not against the person who was the immediate cause of his injury, for the very simple reason that that person didn't have any insurance. Instead, he brought a claim against the householder on the basis that they owed a duty of care to have exercised some sort of supervision. Nothing wrong with the house, in the sense that, nothing wrong with the property, I should say, in the sense that it was well lit and everything. So the only question was whether at the age of 16, there was or wasn't a supervisory duty to look after these kids. If there was a supervisory duty and the parents had discharged that by being out there, no doubt they would have said, actually stop getting on there more than 2 at a time, more than 1 at a time, get off, stop fooling around. So if there was that duty, causation was likely to be established. Now, I use this particular case as an example of where there is or isn't a duty of care. When I was talking to what used to be called the Judicial Studies Board, so you have a mixture of judges, some recorders, some circuit judges, some high court judges. And at the age of 16, the sort of division about who thought there was a duty of care and who thought there wasn't was pretty much 50-50. Change the facts and make the kids 18, nobody would say there was a supervisory duty. If you make it 14, then probably people at that age were beginning to say, yes, we think there should be a supervisory duty. So that's so fact sensitive. It depends a bit on the age of the children, a bit on how responsible they are, a bit on the nature of the apparatus they're playing on, a bit on their previous experience. So infinitely fact sensitive. What do you think, Quintin?
Well, do you think it would have varied with, say, the 16-year-old children when they came into the house if they had appeared to have been, say, drinking? Does that impose more of a supervisory duty because you can't expect them to act as sensible 16-year-olds?
Yeah, I think that's exactly the point. And you could change the facts again. Imagine that it's a light. I think it was dark, but imagine it was light and the parents look out of the window and they see the kids outside behaving stupidly. Do they then, having not had a duty previously, do they then have a duty to go outside and say, stop behaving stupidly? I think arguably they do. Or change it to a swimming pool party. You invite a group of kids round your house. I mean, at what stage do you as the householder or you as the parent of one of the children expect them to be supervised?
And I suspect that's why you'd agree that it's probably too simple to see that there's an absence of any duty because the common law doesn't impose liability for pure omissions, as Lord Gough suggested at one point. I think it was in Smith and Littlewood's. Because as soon as you go to a young child, say 8-year-olds, in the case that you explained earlier, where you're walking along a road, there would be a duty of care, where all it really is an omission in letting them walk out onto the road. We all know there would be a duty of care in that case, and we'll go on to look at why there's a duty with the assumption of responsibility later. And of course, I suppose every failure to warn is a failure to act and is therefore based on omission.
Yeah, well, I'm particularly interested in the omissions point. And I'd remind you of the case of Murphy and Brentford, which overruled Anne's. And I mention Murphy here because it's a case which is put in an appearance in the Grenfell inquiry. And since I'm involved in Grenfell, I shall refer to it only with some diffidence. But the argument canvassed very forcefully, but nevertheless put out there by the Royal Borough of Kensington and Chelsea and the TMO, and if I may say so, firmly rejected by the bereaved survivors and residents, is that no liability could attach to a public authority for an act of omission. And in the particular case, that omission would be the omission to do their job properly as building control, given that it's now admitted that building control should never have given agreement to the refurbishments. Now, straight away, one can see that there is, shall I say, a considerable conceptual difficulty in characterizing what building control did as merely an act or acts of omission.
And isn't the potential point of distinction, and perhaps instructed on it, but the potential point of distinction with Murphy and Brentwood is that the real ratio of that was that there's no liability for pure economic loss in such circumstances. The case of Perrott and Collins, where it was the engineer who certified the aircraft that certified as fit for flying the aircraft that ultimately crashed. In that case, the claimant did establish, and it was a trial of a preliminary issue, that there was a duty of care not only by the pilot of the aircraft, but also that engineer who certified it. And there were all sorts of arguments, and Murphy and Brentwood was mentioned, but it was distinguished in that case, Murphy and Brentwood, because that was dealing with pure economic loss. And those circumstances seem on the face of them to be more similar to what happened at Grenfell.
Yeah, well, I think probably what I should say is quite. The bereaved survivors and residents may well point out that building control's role at Grenfell was rather more than simply signing off an application for approval. They were involved at various stages of the process in improving what had been done. And interestingly, the way in which building control's role was viewed by the other parties involved in the process, and most importantly by the residents, actually engages the two of the key constituents for a legal duty of care that we see in Perrott. Particularly, the residents relied, and indeed so did the other parties, rely on building control to do its job properly, and building control assumed responsibility for so doing. So I think the bereaved survivors and residents may have, shall we say, a high degree of confidence that Murphy wouldn't be of any great help to the Royal Borough of Kensington Chelsea or to the TMO in a case of any material damage, let alone personal injury in a common law claim. And that's even before one considers the state's substantive and positive obligations under ECHR Article 2 and probably Article 8 and possibly also Article 1, Protocol 1, the right to property. But perhaps we should leave Grenfell there, should we not?
Well, maybe I'll move us on then. Why don't we discuss how we best identify the principles, legal principles, on which a legal duty of care depends?
Yeah, well, I mean, this brings me to one of my regular hobby horses who ever listen to me talk about these sorts of cases, which is that it's principle that really matters. You need to find principle, and precedents really only matter insofar as a previous authority can establish clear principles, by which I mean that those previous cases, which have infinitely variable facts, can so easily be distinguished on their facts. So it's principle which really matters. And yet, interesting enough, law students who I see, if ever I give a lecture to them, they still seem to be taught law on the basis of principle. Sorry, forgive me. Seem to be taught law on the basis of precedent first, and as it were, principle second. And I think that's, personally, I think that's dangerous.
Well, what I hope to have learned over the last few years in practice is that generally judges want to get to the just result and will look at cases to derive principle from them, but won't want to be tied in or cornered by any particular facts of the case, because inevitably the facts can be distinguished. And also what
reminding all the time for some reason.
Oh, sorry, somebody else has just come onto this call.
Oh, how interesting.
Yeah, I just heard a female voice entering the call. Anyway, they've gone now. But I don't know whether you sometimes come across cases where concessions have been made which potentially you think shouldn't have been. And that's also a danger of just simply relying on precedent.
Yeah, well, I mean, I don't want to be rude about how other people do their cases, but you do, when you're looking at what is the value of as an authority of a particular case in the past, you do need to see who conceded what. So perhaps my favorite example of this is the upturned boat case, Jolly and Sutton, where leading counsel defendant conceded there was a duty of care, conceded all sorts of things, which actually made it almost impossible, to my mind, for him to win the case. And even more recently, although the defendants did win the case, there's Cockbill and Riley, which is a 16-year-old boy supervision at a barbecue case. I mean, there was a happy ending for the defendant there, but I'm not sure that I would have necessarily thought it right to concede, as they did there, that there was a duty and just decide to fight it on standard of care or the extent of the duty.
And would you agree, William, that when we try and derive some principle, there are probably two parallel but different formulations for establishing that existence of a duty of care? On the one hand, you've got the three-stage test of Caparo and Dickman, foreseeability, proximity, justice, reasonable fairness altogether, and that was applied in a personal injury context in something like the case of Everett and Camojo, the nightclub owing a duty of care to their proximate customers. And then you've got, on the other hand, another way of establishing a legal duty of care, which is assumption of responsibility, reliance on that assumption, and then the catch-all of reasonableness. And you've seen that in Mitchell against Glasgow City Council and also in your case of Poppleton. Do you think there's a movement towards one case, one application of principle rather than the other? In terms of which test?
Yeah, I mean, the first point to make is that both slightly different tests are applied in different PI cases. So you can't say that either has entirely overcome the other. And my own preference, as I think I've said to you before, is I prefer the assumption, responsibility, reliance, and reasonableness as the preferred version. And I think that's probably the one that prevails, but Everton Bojo makes it clear that, you know, foreseeability, proximity, and reasonableness are other ways of looking at the same issue.
Well, it strikes me that they are probably complementary concepts, but I think some people have a problem with looking at what the concept of foreseeability is in that Capara and Dickman case. Because it's
well, I completely agree, and I think perhaps the best analysis of the difficulties with the concept of foreseeability or reasonable foreseeability can be found in the well-known Australian case of Sutherland Shire Council. But maybe the difficulties which were identified there are overcome to some extent by the refinement of the concept of foreseeability that we see in a case like Perry and Harris, the Bouncy Castle case, that we'll speak about in a minute.
Perrett and Collins, which I talked about earlier, which was the aircraft engineer certifying the aircraft, and he certified it for a very small fee. I think it was £20. Certified it as fit for flight. That strikes me as a classic assumption of responsibility and reliance case. And as I mentioned before, Murphy and Brentwood was discussed, and Lord Justice Buxton, in his judgment, looked at that continuing concept of reasonableness and what the assumption of the responsibility was. And of course, what he actually distinguished potentially cases where there was physical damage caused and when there was personal injury caused. But of course, in Murphy and Brentwood, you might just say that's economic loss. I don't know whether you think there are any other good examples of either the Capara and Dickman or Glasgow and City Council.
Well, I think Perrett and Collins is a very good example, as you say, and I think that Lord Justice Buxton's judgment there is as valuable as any as analysis in these cases. Another example would be Watson, British Boxing Board of Control. Remember, the British Boxing Board of Control imposed the rules. You had to subscribe to them. Didn't have any choice. They were responsible for providing medical facilities which proved inadequate. So without question there, all three constituents of both tests were readily satisfied. What about the Radcliffe case?
Well, I know that we've discussed that case, and I struggled to an extent about the imposition of the duty, but that case was the one, for our listeners, where you had the young army officers, one captain, one lieutenant, be off duty with a number of their guardsmen, and they went off into the hills or wherever it was, and there was a river and there was a bridge, and some of the guardsmen were joining in with the locals in terms of jumping off what was, I think, a 65-foot.
Yeah, but they asked, didn't they? They asked the officer if they could do it.
The young men did, but then what happened was Mr. Radcliffe, who was Lieutenant Radcliffe at the time, I think, he asked Captain Jones, "Do you think we should do it?" And what Captain Jones said is, "Well, yes, I think we probably should, because it will show our subordinate guardsmen, our junior guardsmen, that we're not scared." And actually, Mr. Radcliffe, Lieutenant Radcliffe and Captain Jones did jump off that day and actually jumped off without any injury. But then Lieutenant Radcliffe went back, I think it was the next day, it may have been a few days afterwards, and went up to the bridge with some guardsmen and again jumped off the bridge. And it was decided in that case that there was an assumption, even though everybody was off duty, even though it was on a different day from when Captain Jones had encouraged, he certainly hadn't ordered his Lieutenant Radcliffe to do it, but it encouraged the claimant to jump off the bridge. There was an assumption of responsibility. There was a reliance on that assumption. It was thought that it was reasonable to impose that duty of care in that context. Lord Justice May, in that case, referred to a case that you were in, Will, of Poppleton, and distinguished it because in Poppleton there was no such assumption of responsibility as there for the claimant as there was in Radcliffe against MOD, because you had that employer-employee duty. And I suspect that because it was in the armed forces, the extent to which that relationship continued, even though they were off duty, had a part to play. And it was said that even though in Tomlinson's case, this case was after Tomlinson, there wasn't any duty to warn or to avoid adults taking risks that they willingly chose to take. That was different in Radcliffe and MOD. Even though the risks to Lieutenant Radcliffe were obvious, it was different because of that employer-employee relationship and the assumption of responsibility and the reliance on that assumption of responsibility.
Yeah, and I think the other, perhaps the key difference is that in Poppleton, the young man, it was an exercise entirely of his own free will, whereas in Radcliffe, because of the service circumstances, as you say, akin to employer-employee, it's not really so easy to characterize what Radcliffe did as being an exercise of his own free will. But Poppleton was an interesting case for lots of reasons. In a way, I remember it fondly, but I also remember it as another example of the golden rule that one, or perhaps I should say, I can never read a transcript of my own cross-examination or submission without grimacing at the realization I could have done it so much better. If you look at what Lord Justice May was kind enough to say I had extracted from the evidence in his own judgment, I have to tell you, it wasn't quite so clear-cut when we looked at the transcript. Anyway, you remember it was a case about a young man, I think he was in his early 20s, who went to the defendant's climbing centre, which provided an indoor set of walls that you climbed to the top, and then you were supposed to climb down. And he climbed up a wall and he attempted to jump from the wall to a central structural bar and missed his handhold. Or he may actually have just caught the bar and caused himself to swing. Anyway, he fell onto the quite thick safety mat below, but landed awkwardly and broke his neck. And the key point, or a key point on appeal, was whether he ought to have realised that even if you fall several feet, you can still land awkwardly and you can still suffer serious harm. So that was the point that Lord Justice May made rather more forcefully than I had, but I think we got there in the end.
And so you lost that at first instance,
yeah,
and were then successful on appeal. I think you've told me in the past, not only that you write RTT on a piece of paper when you're at first instance,
yeah,
which I think stands for remember the transcript.
Remember the transcript, yeah.
But also, I think you said in that case, didn't you, that the defence solicitor in another case, quite similar to Poppleton, Foles and Bedford, was the judge in Poppleton at first instance. Is that right?
Yeah, well, no, that's true. I do write remember the transcript. I also write shut up. I mean, if in doubt, shut up to myself, because that's generally good advice. I'm afraid I don't perhaps take as often as I should. But no, you're quite right about Judge Foster. He was the defence solicitor in Fowles and Bedford. And another interesting fact about Judge Foster is that it's his son, I think, Fraser Foster, who played in goal for Southampton, together with James Ward Prowse, whose father is also a barrister. So there we are. But just
it's for a bit of a digression, Will.
Sorry, where were we?
Well, and Foles was the one where there was an instructor and a young man doing gymnastics, and there was a duty of care when he collided with the wall, having set up the mats for himself too close to the wall. And why there was a duty of care imposed in that case rather than in Poppleton was because the judge decided but there was a supervisory duty for the instructor to show the young claimant how to do it properly, because he'd started off on that process of training, and he should have said, look, don't do this on your own, always do it under supervision. And then he wouldn't have tried the unsupervised somersault, which took him into the wall. And,
yeah, exactly. I mean, they had at an earlier stage tried to teach him gymnastics, and they should have taught him how to do a somersault properly, whereas in Poppleton, the defendants didn't do anything more than provide a facility, and as we managed to establish, the potential for harm in what the claimant did was obvious, even though the guidelines for that and similar places recognise that a safety mat can provide a full sense of security. But the court decided there was no general supervisory or advisory duty. And you might say the same about someone who provides a skiing area or a toboggan run. People can do what they like on there for their own benefit, but there may be a duty imposed as regards the behaviour of that visitor, that adult visitor, towards other skiers. I mean, you shouldn't let someone on your indoor ski slope, say, who you have reason to believe is likely to behave stupidly, not just because of the danger to himself, that's his problem, but because of the potential impact to others.
And you've also got that those cases, that line of cases almost against, about protecting people against their own free will. You've got the drinking cases, something like Barrett against MOD. There wasn't any duty of care to stop the claimant, who's in the Navy, from getting absolutely plastered and passing out and ultimately asphyxiating on his vomit, until there was an assumption of responsibility when they started to look after him. And when they started to look after him, that's when they had to do things reasonably. Now, I think there was a high level of contrib, but in terms of establishing a duty of care to stop him, his own free will, drinking himself silly, there wasn't one.
No, I agree. In the new chapter, I actually look at the various cases where attempts have been made to impose liability for someone who has got drunk. So the driver, for example, who knows his passenger is too drunk to take care of himself and lets the passenger out into the road. That was a case of mine called Griffiths, I remember, years ago. There have been 2 or 3 more recently. I think, as a rule, courts do generally still expect adults to take responsibility for themselves, outside at least a relationship of employer or employee and its equivalent, such as the services. And that's also why an adult such as Mrs. Geary, who tried to slide down the banisters in a Wetherspoons pub in Newcastle, failed, even though that risk, that potential for harm, had been recognised by the pub manager, and steps were later taken to prevent it from happening by wrapping a big, thick mooring rope around the banister, so that if anyone tried to slide down it in the a la Mary Poppins, they'd been for rather a bumpy ride.
And 2 cases which for me show quite well the distinction between where the law should allow people to exercise their free will and they accept the consequences, is probably the 2 cases of Colassa and Spearman, where Mr. Colassa, drunk, decided to leave A&E and walk outside, go to the wall, sit on the wall, climb up the railings, and then fall off the railings and suffer grave consequences. There was no duty of care for the hospital trust to stop him doing that. But that was different from the case of Spearman, when the trust did have a duty when Mr. Spearman came in a confused state because of a hyperglycemic episode. They did have a duty to stop him wandering off, and I think he fell off the roof or fell off a wall, because he was vulnerable and he was confused, much like Mr. Colassa. But of course, he hadn't induced that state in the same way, because he was having an unfortunate hyperglycemic episode.
Yeah, and that ties in with the MOD cases we were talking about before. Radcliffe and Jepson would be another, But I mean, the question of the extent of any duty imposed in the case of a body such as a hospital can be extremely finely balanced, as you might illustrate by the defendant's success in Darnley in the Court of Appeal. Remember the hospital waiting times case and its failure in the Supreme Court.
Now, it's 4:05, Will. I think we should probably talk about how one defines the extent of the standard of care and how that ties in with what the standards are. What do you think about that?
I think that's a good idea. So they're conceptually distinct. The questions of extent of duty and standard of care, conceptually distinct. In practice, they overlap. And I would say, first, we've moved a very long way in our analysis from a situation in which a claimant succeeds just because he can establish that some risk of physical or mental harm was foreseeable and invokes the merry authority of Hughes and the Lord Advocate, which actually has been introduced against me not too long ago in front of the great jurist Judge Gore. So we had to spend some time distinguishing that and explaining why it didn't arise. Perry and Harris is a duty both about extent and standard. In Perry and Harris, as we said earlier on, the risk of some injury playing on the bouncy castle was foreseeable, but it wasn't reasonably foreseeable that the injury would be serious. Urine and corporate leisure is a case where people were playing around, but the game they were mucking about at only carried a very remote risk of serious injury. And you've got a case like Derby and National Trust, where the defendants foresaw a risk to people going into the lake because of Weil's disease and discouraged people from swimming for that reason, but had no duty to stop the claimant swimming at all because he died not of Weil's disease, but just because he drowned. Likewise, in Borhill and Young, the duty didn't extend, the driver's duty didn't extend to cover a pedestrian who suffered some extreme emotional reaction from seeing the aftermath of the accident.
And in terms of that foreseeability of some injury, I always rely on Blair Ford, which I appreciate was only a High Court judgment, but the facts were that the claimant was engaging in some welly-wanging as a school teacher with his pupils, and the organisers of the event, their way of handicapping the teacher, because he would otherwise have been able to throw it further, one assumes, than most of the pupils, was to make the teachers, including the claimant, throw it between his legs. As it happened, he suffered the most terrible injuries when he collapsed over with the boot going straight up in the air, and unfortunately, I think his head going straight into the ground. He suffered paralysis, but the judgment in that case was, although there was some injury foreseeable, there was no reasonably foreseeable injury, foreseeable risk of serious injury, and then obviously social utility came into it, and so there weren't any steps to take reasonably by those organisers. And I've recently done a case, the claimant did discontinue, but we had to grapple with this because what we had was, it was up in a secondary school up in County Durham. The claimant who was, I think he was about 15, 16 at the time, he was required, along with the rest of the school, to go into very large assemblies, hundreds of pupils standing up in a large sports hall, and I think it was about 500 or 600 of these pupils, and there had over the years been a couple of incidents of fainting, but these assemblies lasted for 5-10 minutes. It wasn't like trooping the colour in searing hot heat. And of course, when those fainting instances had happened, I imagine that they crumpled to the floor, and certainly there was no report of any injury. If one breaks it down into, well, is some injury foreseeable when somebody faints? Then, well, yes, there is probably some injury foreseeable, but the foreseeable risk of serious injury is slight. And we successfully, I suppose, persuaded the claimants not to run it to trial because there was no duty for us to take any reasonable steps to prevent serious injury. I used Blair Ford in that case. I think actually my solicitors did an excellent job of getting all the facts out of the teachers, because the school had actually stopped hosting the assembly. So I suspect the claimant solicitors thought, well, this is a goer. But actually, once we got the witness evidence, we found that a number of teachers thought that they should recommence because they were good for the school ethos and camaraderie and cohesion. And also that one of the reasons they'd stopped them was out of some respect for the claimant and his family, who'd obviously suffered a life-changing injury.
Yeah, I think defendants shouldn't be panicked by the fact that they've improved things with the benefit of hindsight, or done more than perhaps they legally need to do with the benefit of hindsight for whatever reason, as I think had been true in Poppleton. But let me pose a factual situation to you that interests me, and it's 2020 cricket, in the happy event that at some stage cricket does return to our screens or to our eyes. Now, in 2020 cricket, indeed in all cricket now, but particularly in 2020, the players are encouraged to hit the ball into the crowd. Indeed, spectators seem to take delight in either trying to catch the ball. If they do, in some grounds, they get a cash prize. But anyway, it's eminently foreseeable that the cricket ball is going to sail into the crowd more than once in the course of this game. And it's, I would have thought, perfectly possible that when somebody doesn't catch it, which is very foreseeable, the ball hits somebody on the head and perhaps causes a serious eye injury, for example. Now, you might say, I don't know what you think, but you might say, well, the adult in the crowd who gets hit on the head when trying to catch the ball, he or she can't complain because they know the risk and they embrace the risk. But not everyone in the crowd is necessarily going to have been aware of, still less consented to the risk. They
encourage children.
Might be a child.
Yeah.
Yeah. So
also, they're developing the 100 in the county game, and they're actually encouraging people to go who haven't been to cricket. So it's going to be very difficult to run a consent argument on that front. So
yeah, I think personally, consent's got nothing to do with it.
Nothing to do with it, no. I can understand that.
Yeah, I mean, consent might be an aspect of reasonableness, in that a significant proportion of the crowd are aware that there's a risk and that the child goes there with an adult who might be aware of it. So in terms of standard of care, that might be a factor. But I personally think it's more likely to succeed. Defendants is more likely to succeed on the basis that the risk of serious injury is actually very, very remote indeed. And despite all the balls that have been hit into the crowd all over the world, the occasions on which anyone has actually been seriously hurt seem to be very, very few and far between. So it's, I would have thought, more likely to be a Perry and Harris or a Borehill and Bolton and Stone kind of defence that prevails if it does.
William, it is 45 minutes.
Do you agree?
Yeah, I absolutely agree. And I think going back to, it was Penning in Bolton and Stone, that's a law school case, isn't it?
Yeah.
I think going back to that case, the principles will still apply in the 2020. What happens if, I don't know whether any grounds though will start putting up screens if there's an injury, and that might then change the analysis. It shouldn't, I don't think.
Yeah, but would it be reasonable to do that? Because the moment you start putting screens in the way that
people don't want to come.
Caging in the old days with football, I mean, actually, it diminishes the pleasure of everybody else, doesn't it?
Absolutely. I agree. But one never knows what reactions may be.
Now, you were talking about questions. So we also need to think about our audience here, Quintin, because the numbers have dropped by 6
in
the last 5 minutes.
Oh, well, you've obviously been keeping a beady eye. Maybe it's the frustration of us not having answered the questions that are there.
No, we haven't. Oh, so we've got some questions.
I think some of them might be more comments.
Oh, yes. Let's see.
The first one, as you can see, you can choose whether to read that out.
Well, I am going to read one out.
Whacked on this, Will.
I'm going to read one out. It's from my friend Paul Paxton,
I thought it might be.
who says, "God bless Alan G." And with that, I entirely agree. Somebody else pointed out the claimant won in urine, which I think we knew, but that's one of the various factors we had in mind. And then have you got this one from Gregor Woods?
Yes, I'm just reading it now. Shall I read it out? If it is possible to argue that an injury is more serious than that which could reasonably have been foreseen, how do you marry that with the eggshell skull principle? So I think, well, I'll leave this question to you, but it's going to be analysis of the Hughes against Lord Advocate, isn't it? And looking at things like Blair Ford,
Smith and Leach brain and so forth. Yes, I mean, the answer is that once there is a duty, once you decide there is a duty to take steps to protect any claimant from risk of injury, then the claimant will succeed, notwithstanding that he has an eggshell skull. But in our 2020 cricket example, we're saying that actually there isn't a duty because the overall risk is so small. The overall risk of serious injury is so small.
I think that's right, and I hope that's an adequate answer for Gregor Woods.
Well, it's the best we can give.
Yeah.
But it's a good question.
It is a good question. I don't know if any. There's another one coming in because it says open 5. No, we're only 4. Oh no, Gregor Woods is responding. Thank you very much, Gregor, for responding, saying thanks. Thanks, as opposed to saying no. You have to ask.
At least you didn't say nonsense.
Well, Will, what would you like to do?
Well, I tell you what. No one's ever been disappointed when a show finishes early. At least
you can go back and read it in your
not in my experience. What we could just do, just very briefly, is I wonder if we might just talk about some of the swimming and diving cases, because I think they're quite interesting. Should we just spend 5 minutes talking about swimming and diving cases? Just start with Tomlinson. The defendants there, I mean, they tried to bring the claim under the 84 Act, but the defendant there recognised there was a potential risk of injury, and they had given serious thought to trying to prevent people swimming in the lake. Should they have taken steps to put the whole place out of bounds, or was that entirely unreasonable? Well, the answer is, I think you're not likely to get very many better judgments than Lord Hoffman's in Tomlinson, analysing not only what is meant by the state of the premises duty under the Occupiers Liability Acts, but also explaining the importance of free will and how you can't always expect a responsible organiser or a responsible landowner, as there was in Tomlinson, just because they thought they ought to take steps to prevent things, therefore they should have prevented it absolutely. Likewise, in Derby and National Trust. Grimes is a case that you may know about. Again, it's a first instance case, but I think quite a good judgment. It was an 18-year-old girl who went to stay with a party organised by a friend of hers. The parents left them to it. There was an indoor swimming pool, and the 18-year-old girl, after they'd all had a few drinks, dived into the wrong part of the swimming pool. Was there any duty to put the swimming pool out of bounds, as was argued? The answer was no. Was the swimming pool inherently dangerous? No, it wasn't. It was obvious where the place was too shallow to dive, and the claimant was old enough to be allowed to take a risk and did so. But what about a case like O'Shea and this question recently of lifeguards not being on the beach? O'Shea was a public pool. What if the defendants had actually not provided any lifeguards at all at O'Shea? Could the claimant there have succeeded, do you think?
So it's not a public beach. It must have been a private beach.
No, O'Shea was a public swimming pool.
Oh, sorry, I misheard.
Yeah, no, O'Shea was.
I don't think the claimants would have succeeded unless they assumed a responsibility for putting lifeguards there, because if it's a young child, they shouldn't be there unsupervised, but it's not reasonably foreseeable, particularly that the children would be there unsupervised. And isn't it somewhat similar to, is it where the case in the caravan park, where there was an unguarded lake and the 2-year-old tragically wandered off and was drowned, but there was found to be no breach of duty.
No duty to point out exactly where it was and to highlight the dangers.
Quite.
But the thing about the O'Shea case is that I think, from memory, lifeguards were provided and weren't doing their job properly. So once you provide lifeguards, there may be perhaps not an explicit, but an implicit assumption of responsibility and reliance. Baldacchino was Neil Bloch's case about someone who dived off a harbour marker of some sort on West Wittering Beach. Do you remember?
Yes.
Quite the basis on which the claimant put the case was never entirely clear, because if they hadn't provided lifeguards at all, would the claimant have been in a better position than providing lifeguards who didn't stop? I'm not so sure. So I think that all I would say about the swimming and diving cases, you go back to lots of them, like Evans and Cosmar or the Donahue, all those cases, I just think one needs to start, as always, with first principles. That's to say, what is the nature of the duty? Is it an occupier's duty that's alleged, or is it a general duty of care? And on what basis does that duty exist? So I think that was what I would say was the key to those cases, if we needed to look at them.
Well,
I think we're going to finish ahead of time, Quintin. Oh, we got another question.
Another couple in. Well, Howard Mansell, who is an instructing solicitor of mine. Don't think it's a question, I think it's a comment.
Well, here we are. So Chris across the Dulu asked, beaches are busy now with few lifeguards around them. Will there be a surge in claims for not putting? I think that's a really good question. And my answer is there certainly should not be. I mean, first of all, I think the RNLI is completely exceeding its brief by trying to call for the government to ban people from going to the beaches. Seems to me that people are perfectly entitled to go to the beaches. If there are no lifeguards there, it should be obvious. They may put up signs, if you like, to say this is a beach without lifeguards, but I absolutely think people should be entitled to swim where they like. Right. If there are lifeguards there, they should do their duty properly. And for the reasons that we've given, I think once there are lifeguards, you've assumed a responsibility and people may rely on them. But if there aren't lifeguards and there's an accident, you have no one to blame but misfortune or yourself.
Well, I always think when they put those flags in the beaches, that's the prime example of a swimming area. Swim here, you'll be supervised here. There presumably aren't any rip tides known here. That's a classic example of there is an assumption of responsibility, and for those who swim in it, there's a reliance on that assumption of responsibility. But otherwise, if you go into the water anywhere on the beach, it's at your own risk. Your own and sometimes that's why you do, because it's exciting.
Yeah, I mean, again, sometimes it can be difficult with the obvious danger point. So you might have a beach which looks particularly inviting and a sea that looks beautifully calm, but actually just a very few feet offshore, there's a very deep shelf and there are very strong currents. Would there be any duty on the beach owner to warn people of that danger because it's not obvious to everyone? Again, I don't see why there should be. People must be able to make their own mistakes in life. And that's a tragic one, but that happens.
I agree.
Right, number 8. And then I think we'll thank everyone for attending. I think we're there.
We've got Howard Mansell, foreseeability of some injury versus severe injury. Thought 8 House of Lords ruled still liability, presumably because duty of tale to exist already. Going to eggshell skull. So what I think Howard's brought us back to the Hughes and Lord Advocate point, William.
Yeah, well, which I think the answer is Perry and Harris.
Quite.
And what we said earlier on about...
There has to be a severity of injury foreseeable to impose any duty.
Correct.
Hughes and Lord Advocate still good law, because there was serious injury which was reasonably foreseeable. It just wasn't reasonably foreseeable in the way in which it occurred. And that's why there was an imposition of liability. But no doubt Howard can do that.
And once the duty, as we said, once the duty is agreed to extend to cover the kind of accident that actually occurs, the fact that this particular claimant turns out to be especially vulnerable is misfortune. That's the defendant's bad luck.
Yes. Good.
Okay, I think we will wind up there. Say again?
I think we're finishing on time, which is good.
Yeah. Thank you very much, anyone who's continuing to pay attention. And thank you, Quintin, and thanks everyone else who's been supporting us and making sure that we've been audible, as I hope we have.
All right. Thanks very much. Thank
Okay.
you. Thanks, everybody. Bye-bye.